In many ways, the DAG is the chief operating officer of the Department of Justice. It's the number two position there, and it really is the position from where many of the most significant policy decisions are made.
That was FCPA Compliance Report fan favorite James Koukios, introducing this episode of the FCPA Compliance Report, where James and I take a deep dive into the speech by Deputy Attorney General Lisa Monaco back in October, announcing new Department of Justice focus on white-collar crime, FCPA enforcement, the use of monitors by the Department of Justice, the focus on culture in corporations, and reinstatement of the Yates Memo and revocation of the Benczkowski Memo. This is a significant issue for every compliance professional, and I wanted to take a deep dive with James on this for your education. Hello, everyone. This is Tom Fox. Welcome back for another episode. And today I have back with me fan favorite James Koukios, and we're going to talk about a couple of his law firm, Morrison and Foerster's, top 10 international anti-corruption development newsletters that appeared in Q4 of 2021. I asked James if we could dedicate the October newsletter to the Deputy Attorney General Lisa Monaco speech at the ABA White Collar Conference. So we're going to take some time to maybe dissect that speech, first giving some of the broader outlines and reaches from Monaco's speech, and then maybe drilling down a little bit about what it might actually mean for people like James who are external counsel to a number of companies and some compliance practitioners and perhaps companies going forward. So James, first of all, hearty 2022 and welcome back to the podcast.
Thanks, Tom. Happy New Year, and thanks for having me.
James, one thing I've learned, I started in this field about 2007, is that we've seen developments from the Department of Justice. The Department of Justice, I don't want to say it ebbs and flows because we have changes in administration, but we also see the Department of Justice reflect to facts on the ground or react rather to facts on the ground. As situations change, they may take new and different positions, and it seemed to me that that was what occurred in October when Deputy Attorney General Lisa Monaco gave her speech. I've not had the chance to ask this question, so let me start with asking, why is a DAG speech so significant? Who is the DAG, and how does the DAG relate to the fraud section or the FCPA unit?
Sure, it's a great question, and I'll be honest. I started my DOJ career as an AUSA in Miami, pretty far from Washington, D.C. and Main Justice. And I'm not sure I actually knew exactly what the importance of the DAG was, even when I was a federal prosecutor to start out with. So it's a fair question. In many ways, the DAG is the chief operating officer of the Department of Justice. It's the number two position there. And it really is the position from where many of the most significant policy decisions are made. Obviously, the Attorney General is the number one slot, and at the end of the day, the buck stops there. But when you're really talking about department policy, it really is the DAG who's out in the forefront, deciding what policies and procedures the line attorneys at DOJ will be taking. So whether it be discovery issues or how to deal with corporate defendants, or you name it, when it comes to a big policy issue, it's really the DAG who sets that. And that's why a lot of policies are known by the names of the DAGs, like the Yates Memo or the Philip factors. Those were DAGs in the past who announced major policy changes or initiatives and were named after them. It's particularly significant that what the DAG says for corporate criminal enforcement. It is for individual enforcement as well, but when you get into business crimes, because a couple of reasons. Number one, a lot of those cases are made out of D.C., which is just geographically close, obviously, to the DAG, who's in D.C. at Main Justice, so you can go over there and meet very easily. But also, the corporate cases, no matter where they take place, they tend to be of pretty high profile and pretty high importance to the department. And so when the DAG announces a corporate enforcement policy or a change to corporate enforcement policy, it really does affect what the line prosecutors do, what companies have to do when they are before DOJ, and it's really significant. So, over here at the top 10 international anti-corruption developments newsletter, we pay particular attention to Dag speeches because they often signal changes in corporate enforcement and therefore FCPA enforcement that we need to pay attention to.
So I saw three broad outlines in Monaco's speech, and I wanted to see if one you concurred with that, and maybe if you do, we can drill down a little bit. But number one was, I'm going to call it the reinstatement of the Yates memo, but the requirement that corporations fully investigate all potential participants and turn over all information to the Department of Justice. Number two, the Department of Justice will review not simply FCPA prior conduct in FCPA matters, but really all conduct. And that's not only for FCPA matters, but they want to know if you've had antitrust issues, EEOC issues, or a wide variety of other issues when considering a potential penalty or a declination. And number three, a revocation of the Benczkowski Memo, moving back to more utilization of monitors. Is that what you saw as maybe the three broad brush elements of the speech?
Yes, I would. When we get to number three, I'd characterize it a little bit differently, but there's no doubt that a change in at least perception or practice around the Benczkowski Memo for sure was one of the messages.
So let me start with number one, which was, I've called it the reinstatement of the Yates Memo, but number one, corporations or probably more importantly, people like you have to do additional or more investigations, but that information also has to be turned over to the Department of Justice, and the Department of Justice will make an evaluation on whether they choose to move forward. If that's a fair assessment, how do you see that playing out in practice, James?
Yeah, it's a good question, Tom. When the Yates Memo first came out, it was obviously very tough talk about individual enforcement against individuals. And the first principle was that companies to earn cooperation credit had to provide all information regarding everybody involved in the misconduct. That was it was very broad. All individuals, to get any credit, you had to do this. And then under the Trump administration, they pulled back on that a little bit. And sometimes I wonder if words do matter, obviously, but I sometimes wonder if it's a really big difference in practice versus how you articulate the principle. But under the Rod Rosenstein, they changed it to say that you had to provide information about all people who were substantially involved in the misconduct. And now with this recent speech by Dag Monaco, it's back to all information about all people involved in misconduct. I think a lot of that is an interpretation of the detail and what you know as an investigator. When you're investigating something, you don't always know all the people who are involved. You obviously focus in on the people who seem most likely to have been involved. You follow the leads, you follow the significant actors where the evidence, you interview witnesses, they tell you so-and-so is involved. You look at documents, you see names on things, and you talk to them. And I think for the most part, most practitioners would talk to those people, get their documents, and provide the information to DOJ. Query what it means to be involved in misconduct. For example, if somebody just hit the payment button, they're just an accounts payable person. There's no indication that they had any involvement in the actual misconduct at all. They just were a functionary, for lack of a better word, and pressed the payment button that got a third party paid, and then money was later used for a bribe. Was that person involved? Was that person not substantially involved? I think there's depending on the interpretation, you could say that person wasn't even involved in the misconduct because they were just pressing the button. The substantially involved kind of made it a little easier for practitioners to not have to kind of say, well, in this world, she's sort of involved because she pressed the button, or he's not involved, and so the substantially involved, I think, was a little bit meant to not let companies off easy, but to make it a little bit easier to make those determinations. But now DOJ is saying, we don't want you to make those determinations. You need to tell us everything. But I still think just exercise of regular judgment, people are going to have to make those decisions and try to interpret that, what that means. That said, usually when you're in an investigation with the government, you're cooperating with the government, there's a lot of give and take. There's a lot of back and forth. Sometimes you don't know the full picture when you first come in and you tell the DOJ and SEC or whichever agency it is, like, these are the people we think are involved. And then as you go along, you may supplement that list, or DOJ might look at a document and say, hey, we think that person was involved. I would hope if that happens, the latter, where, you didn't focus on somebody because you didn't think they were involved, but DOJ sees a document, think they are, that you would still get cooperation credit. But it leads to some difficult interpretation issues. That was a long answer, Tom, but I think that's kind of, I see it as very nuanced about who's actually involved, but it's really at the margins. If somebody's clearly involved, you're going to tell DOJ about it. You're going to make, you're not going to hide that.
So, James, next was this concept that the DOJ wanted information on all legal violations, enforcements, or perhaps even investigations. And there was another part of Dag Monaco's speech where she talked about corporate culture and the importance of corporate culture. And to me, actually, these 2 points were tied together because although I don't know if I made that up in my head, because I'm not sure she really made that explicit connection in her speech, because I heard her talk about culture and then flip to other legal violations the company may have engaged in. And it seemed to me that she was having a broader outline about corporate culture, and the DOJ wants to assess whether or not you follow the rules in other areas. I don't know if you found that accurate or not, but I do know that one of the areas that I've seen the most, if not pushback, at least discussion by the white-collar defense bar, particularly at the ACI National FCPA Conference, was on this prong. And a wide variety of concerns raised by other white-collar defense practitioners. And I was really wanted to get maybe your thoughts on this prong of her speech.
I think you're onto something there, Tom. And I also think that the reason this got so much play is this is probably the most, I think, significant part of the speech, because it really could open up, when you're talking to DOJ about a resolution, a lot more subject matters, and it may make it much more difficult to get a deferred prosecution agreement or a non-prosecution agreement, and it may make it easier to get breached, even if you do get one. So it's interesting. What she said in her speech is that going forward, prosecutors will be directed to consider the full.
We're going to have a quick message from our sponsor, and then we'll be right back with more from the FCPA Compliance
when deciding
Report.
what resolution is appropriate for a company that is the subject or target of a criminal investigation. That's extremely broad. Especially for large multinational corporations that have tens of thousands of employees and operations all over the world. It's possible that you could have a foot foul in one country. You could have an environmental problem here. You could have a FCPA problem there, and none of them could be related. Different people, different regimes, different plants, different root causes. But now they're all potentially on the table, and you're going to have to talk to DOJ about them. Now, the one thing, and I think this gets to your point, Tom, is she did add that some prior instances of misconduct may ultimately prove to have less significance, but prosecutors need to start by assuming all prior misconduct is potentially relevant. And what I think that does tie into your culture point, because if you just happen to you bought an aging plant and it had some environmental problems, you pled guilty, but it sort of wasn't because you're a bad company. It was the circumstances versus, the reason you had an environmental problem was because you don't take control seriously, and there is a profit over safety or profit over environment culture. And then that seems to have motivated the FCPA violation. in the corporate fraud violation and what have you, I do think that's where it gets to be less significant versus more significant. Is this more a pattern of a bad corporate culture, such that an NPA or a DPA would be a bad resolution, versus are these isolated instances, they don't reflect upon the corporate culture, and therefore we can still trust a company with a deferred prosecution agreement or a non-prosecution agreement despite their record. Either way, when you're going in to negotiate a resolution with DOJ and you get to the Philip factors presentation and you start talking about that history of prior misconduct, quite realistically, that could be a much longer and more difficult conversation. And the company and their counsel are going to have to be much more prepared and ready to answer for those prior resolutions, the prior instances of misconduct, to explain why there should be of less significance, why it doesn't reflect an overall culture of non-compliance, and why you should still get a more favorable resolution despite these things. So I think it upped the stakes, and I think it made companies and defense counsel job much more difficult in that regard.
James, the third general theme was around monitorships, and here I saw three parts to Dag Monaco's speech. Number one, that I saw revocation of the Benczkowski Memo, although I know now you saw it a little bit differently, but that the DOJ would put monitors back on the table for consideration for three reasons. One is that they want to use monitors to basically extend their reach, which I think we've both seen done in the past. Number two, it allows companies to actually have a true subject matter expert, because I find monitors to really be almost uniformly subject matter experts in compliance, or at least their teams, to put in a first-class compliance program. But number three, though, was perhaps a little more troubling, which was the issue of recidivism and FCPA recidivists, but also companies who had not fulfilled their obligations under their settlement agreements, whether it be a DPA or NPA. And that it seemed to me the Department of Justice was thought that having a monitor in place might act as an early tripwire, or perhaps prevent either of those eventualities. That led me to think that perhaps the DOJ thought companies were not taking their obligations as seriously as they should under a settlement agreement. A recidivist is, I think, a different type of animal. But what were your thoughts on the monitorship prong? We're going to have a quick message from our sponsor, and then we'll be right back with more from the FCPA Compliance Report.
So first of all, there's no doubt that the Dag's speech was a signal that this administration is going to be much more pro-monitor, and that they're going to see monitors as a much more acceptable requirement of a resolution. So I think that's definitely accurate. I don't think it's technically a revocation of the Benczkowski Memo, and let me explain that a little bit. When I read the Benczkowski Memo, when it came out a couple of years ago, I did not see it saying that we're not going to use monitors anymore. In many ways, I saw it saying, here are the procedures that we're going to follow in terms of deciding whether we're going to impose a monitor. And a lot of this stuff wasn't new in terms of practice. It had been the practice that had developed over years, led largely by the fraud section, but really kind of codifying what that informal practice was, which I saw as a good thing because it was giving people more transparency about what to expect, what's going to happen when you have to talk about a monitorship with DOJ. There was talk in there about having the monitors have a more focused scope to prevent scope creep. And there was a talk about making sure that they were used in appropriate cases. Now, those were the words. That's how I interpreted it. Not that I interpret it not as saying we're not going to do monitors, but we're just going to be very thoughtful when we impose them, and here are the procedures and policies we're going to follow. A lot of people interpreted it as this means they're not going to use monitors. And maybe that was correct, because there's no doubt that the use of monitors did tail off. And so, maybe I'm being overly technical when I'm saying it, it's not really what it said. But I actually think that the DAG actually in her recent speech allowed for that, because what she actually said was, to the extent that prior Justice Department guidance suggested that monitorships are disfavored or are the exception, I am rescinding that guidance. And again, I think what people read between the lines was it was suggesting monitors weren't there, and the DAG wanted to make that monitors would not be favored, and the DAG wanted to make it clear, however you read this, let everybody know we do not disfavor monitors. We're going to use them, maybe for the exact reasons you're saying, Tom, is its ability to extend the resources, but we believe that they're, don't mistake us for the last guys. We think that this is a viable requirement for a resolution. And I do think it ties into your last point, which is there does seem to be a view from the current leadership that companies are not taking their obligations under an NPA and a DPA seriously, and that therefore they might need to use monitors more often to make sure that happens. I'll say, though, it's interesting. When I was at the fraud section doing FCPA cases, we had pretty limited resources. There weren't many of us. And the self-reports, it was hard for us sometimes to really dive into the self-reports. Not that we didn't do it, not that we didn't try to do it. And there were cases when I was there that were extended because of, self-reporting cases where things came up. But it was a little bit more challenging for us to really implement the self-reporting as well as a monitor could. Over the last 5 years, DOJ has so many more resources. The fraud section in particular has so many more resources. They have people dedicated to DPAs and NPAs. They read the self-reports so much more closely. They really grill you about them. And they expect you to include a lot more in those self-reports than used to be the case when I was there. So I'm not, I understand where the DAG is coming from, but I actually do think that under the current practice right now, especially in the fraud section, the self-reports are pretty searching and pretty well monitored. That said, to your point, there's no doubt that an independent compliance monitor is much more searching, and for a troubled company can really help it put a compliance program in place. So anyway, I think everything that you've said was right on, Tom. And there's no doubt that this is a signal that we may see more monitors during this administration. I'll say also, just to add, we didn't see as many FCPA resolutions this year as in prior years. I don't think that has anything to do with FCPA cases going away. I do wonder how much of that is because the resolution process has gotten more complicated because of all the factors that we talked about just now. Are they revisiting to make sure that the company disclosed all the evidence of all the individuals involved? Are they going back and doing a more thorough analysis of the company's criminal history? And are there more protracted and difficult discussions about corporate monitors? And I think that might be one of the reasons, actually, why we didn't see quite as many FCPA resolutions out there. It's not going away. FCPA enforcement, obviously, is still a huge priority for the administration. But I wonder if the resolution process has gotten a little more complicated and a little more lengthy because of some of these new policies. As people figure out, what do they mean? How do we account for them? How do we respond to them, both on the prosecutor side and on the defense counsel side?
James, I'd like to end with a couple of questions. One, I think we'll call upon your experience from your public service in the department. And the second is more in your current role as white-collar defense lawyer. Question one is the FCPA enforcement regime currently in place in the United States and has been in place since both of us have been involved, is part of it's tied around self-reporting. and it's being a good corporate citizen. But if you make a mistake, going to the Department of Justice, and as you have talked about, having an investigation, turn it over, negotiate, give and take, and a resolution appears. Do any of the things in the Monaco speech sort of tilt the decision that a company may make away from self-reporting? And I have the vision of a seesaw or teeter-totter in my head as we slide down it. And that leads to question number 2. We have talked about over our podcast history, one of the most difficult conversations you as outside counsel would have, and one of the most difficult decisions a company have, is whether or not to self-report. And it seems like to me the facts you've laid out have really, if it's not made those more difficult, they're certainly more complex now. And when you really sit down with a client and really have to go through those. And so I really wanted to ask you those kind of 2 questions. Number 1, are we really moving away from companies being incentivized to self-report? Not to say that they wouldn't do an investigation and remediate, they just wouldn't self-report. And 2, is your conversation with a client now more complex or even more difficult because of the factors, some of the factors we've laid out from the Monaco speech?
Those are great questions, Tom. It's interesting. Every time that DOJ comes out and makes a very, pro-enforcement, fire and brimstone type of speech, I know from being on the inside, the idea there is we're going to incentivize you to cooperate because we're going to tell you how bad it's going to be if you don't. But the problem that you hear on this side is, well, why am I going to open myself up to all of this fire and brimstone if I can just, investigate, remediate, and go along? And so it does, I never know which way it calibrates. And these are difficult issues. You don't want to sound lenient on corporate crime because maybe that encourages more crime, but you don't want to sound too fire and brimstone because maybe that discourages self-reporting, as you mentioned. And I think one thing that would be interesting is that Dag Monaco said at the end of her speech that they're going to be really studying a lot of these issues. They're going to be looking at NPAs and DPAs and recidivism and things like that. And one thing I would hope that they would look at as part of that is the effect that some of their policies have had on things like self-reporting and cooperation and things like that. I always thought the FCPA Corporate Enforcement Policy with the declarations with disgorgement was not a good thing to add because, do companies want to? You used to be able to just get a declination. Now the best case scenario is you pay money and your name gets out there as a bribe payer. And so does that dissuade companies from reporting or not? So I think it does make things much more difficult, especially if you're a company that has a prior history. Because what do you do? On the one hand, maybe you feel like we've got this prior history. If we don't self-report and cooperate, and they find out about it, it'll be so much worse for us because the DAG has said they're going to crack down on us. And the DAG has said if you're not transparent, it's going to be even worse. And so maybe because we have this prior environmental resolution and this prior False Claims Act resolution, we got to come in and report proactively because it's going to be so bad for us. And I've had clients say that. Clients who've had prior issues have said, we feel like we have a lower threshold for reporting because of our prior issues. And maybe the DAG's speech lowers that threshold even more. On the other hand, if you're a company that has a prior issue, do you say, look, we can't disclose this because we're going to be labeled a recidivist and we've just been told we're going to get launched to the moon if this happens. So let's just clean it up, fix the problem, and hope that they don't notice and have it go away. So it makes it very difficult. I'd say I think it's not to be too much of a lawyer, but it really is a case by case determination. What is the corporate culture? What are the pros and cons of doing both? What's your best guess? As always, if you think somebody's going to get ahead of you, if there's a whistleblower or a disgruntled employee or something like that, or a newspaper reporter who's going to report on this, that favor kind of tips the balance in favor of reporting. But I do think speeches like this, they can have a mixed result. Not that it's the wrong speech, and not that these are all difficult policy decisions on the DOJ side as well. But I do hope that they take a look at maybe getting some statistics and maybe, talk to people in the industry, maybe even on an anonymous basis, to try to just gauge, what has been the reaction to these things, and what will people be more or less inclined to self-report and cooperate because of these things. And the Dag speech does open that up. She said at the end that she's going to create an internal task force, and it suggests that task force is going to reach out to the industry to talk to them. So I think it'd be great, and I think it'd be great to hear the results of what that is. We did something very similar with the FCPA resource guide, where we talked to people in the industry, and I thought it was invaluable. We didn't always agree with what we heard, and we couldn't make everybody happy. But kind of getting this is how your decisions are impacting us, and this is what we'd like to see different, and this we think would actually be productive if you did this, was pretty valuable. And I think, if she's open to it with this task force, Dag Monaco, this could be a really good opportunity to really test that. Like, why are we seeing more examples of recidivism? Are we actually seeing that much recidivism? When companies hear about recidivism, does that make them more or less likely to self-report and cooperate? I think it would just be really good to get some data and some concrete experiences that you don't always get when you're within the department. You need to go outside to get that kind of perspective.
Well, James, that's a great way to end our podcast, because that's actually been my observation sitting on the outside. And actually, I think we have both been a part of that process. But my observation is that the Department of Justice does listen, and that they have made policy changes, and they have made different foci, if I can use that word, of different types of enforcement. I was part of the monitorship discussion in the middle part of the first decade, leading to later in the Obama administration. So I think we saw some changes there. So I've seen, and from the department side, Mike Volkov has really always said the DOJ always signals what they're going to do, and you just have to listen. And now it's explicit because we've had the resource guide and the evaluation of corporate compliance programs and other formal documents. But this speech, I thought, was really invaluable to communicate to us, the compliance community, and you in the White Collar Defense Bar, that this would be a focus, and that we could have a dialogue on that focus. So what a great way to end this podcast. Us agreeing again.
Always, Tom. Thanks so much.
This is Tom Fox again. Thank you for listening to this episode of the FCPA Compliance Report. I hope you will check out my 5-part podcast series on the trial of the century, the Enron trial, which recently premiered on the Compliance Podcast Network. In this podcast series, I visit with business journalist Lauren Steffi, who covered the trial for the Houston Chronicle as its business columnist. We take a look at what led to the trial, some of the key witnesses and moments from the trial, and what the trial inevitably meant going forward. It's a fascinating look at the Enron trial some 15 years after it occurred. I know you'll enjoy this special podcast series. The FCPA Compliance Report is a production of the Compliance Podcast Network.
This podcast is a part of the C-Suite Radio Network. For more top business podcasts, visit c-suiteradio.com.